We just started recording, so we'll wait a few minutes.
Hi, this is Teresa Gavarone joining.
Senator Gavarone, Judge Zamuda, thank you for joining us.
Oh, I'm happy I was able to. We were supposed to have committees in session today. Actually, the Judiciary Conference or committee was supposed to meet today, and things just got canceled. So I'm glad this worked out.
Is the House meeting, do you know, Senator?
No, I don't think they are today. There was like 17 House members missing.
Oh boy.
Yesterday. So I think everyone was sent home because we're going to be back next week trying to wrap things up.
Yeah.
And possibly the week after that. So I don't know exactly how it's all going to look just yet, but we're home today. So this worked out.
Very good.
Yeah. How's everything going with you? Everyone healthy and doing well?
We're as healthy as can be. It's, you know, and yeah, we're doing well up here on the 6th. So year-end stuff for us as well.
Very good.
Let's see. I have Jason. We have Justin. Excuse me. We have 16.
Yes, we're waiting. I mean, as far as it looks like, people who have not said they would not come. We're still waiting on Judge Cost, Judge McIntosh, Douglas DeMoult, and Meredith O'Brien.
All right. I have 10:02, so I'll give them another minute and then we'll get started. Looks like one's in the waiting room.
Yeah, I just let her in.
Oh, Meredith. All right, very good. Hello, Mark Godsey. I didn't see you there. And Elizabeth Miller, good to see you. Let's see. And Meredith O'Brien has now joined us. Good morning. All right, let's get started. Good morning, everyone. Thank you all for being prompt and joining us. We're called to order the December 10th meeting of Task Force on Conviction Integrity and Post-Conviction Review. Thank you for your continued participation and engagement with us in this very important and crucial work that we're doing at the auspices of the Supreme Court. The agenda item you should have received, as well as the biography of our guest presenter, Maurice Posley. We'll get to that in a moment. First item on the agenda this morning is approval of the November 19 minute meetings. Meeting minutes is the way to say it, Gene. Hopefully you have each had an opportunity to review those minutes. Any comments, corrections, deletions, additions that anyone would like to raise at this time? Silence. Silence is golden, right? Not just with children, also with elected officials and important judges. Do we then have a motion by way of raising of a hand to approve the minutes? Judge Bergeron, thank you, sir. Do we have a second? John Martin, second, was the first one to raise his hand. Thank you. All in favor signify by raising your hand. All right, thank you. Opposed? All right, minutes are approved. Now, I do have to comment on this. Justice Donnelly, you'll find this interesting. Sarah Andrews and I presented to the Common Pleas judges of Cuyahoga County earlier this week about another initiative that Sarah and I are working on with respect to the felony data database and whether or not Cuyahoga County wants to volunteer to to be part of that pilot program. And so we were invited to participate in their judges meeting by way of Zoom. And what they do there is they'll go through and they'll ask an introductory question of everyone. The question that they posed is, since this is the holiday season, what is your favorite holiday movie? And which character would you be in that holiday movie? And why? Now, Justice Donnelly, I'm picking on you because this is your former bench. And there are 34 judges of the Common Pleas bench, of which, Sarah, how many do you think were actually in attendance? 20, 25 maybe?
At least. Yeah. There were only a handful that weren't there.
Right. It was probably closer to 30. So we start the meeting with the administrative judge saying this is what we're going to do, and then they go through the list alphabetically. So we spent a half an hour because when you go through because there was a discussion. So I told Sarah, I said, well, this is a great icebreaker. It's a way to get the members of the Zoom meeting to be engaged. So I think we have a smaller group. We don't have 34. We only have 17. And I think we should be concise and start this. We have Maurice Posley isn't available until 11, as you all know. Well, I think you all know. He's actually residing in Laguna Beach out in California. So when he said he'd be available 11 o'clock our time, that's actually 8 a.m. his time, and he says that would be fine. We have a little time to fill, so I'll start. We're gonna do this, and I'll start. So my character is, of course, the judge in Miracle on 34th Street, because there really is a Santa Claus, despite what other rulings and other people say. That's my character, my favorite movie. Justin, you're up, buddy.
I will
favorite movie, favorite character, and why you would be that person.
We'll go with Die Hard because it's a true Christmas movie. John McClane because he saves Christmas.
Very good. Sarah Andrews.
Yes, I'm George Bailey in It's a Wonderful Life.
Why?
Because it's such a great story.
There you go.
Should all
Okay.
take a moment.
Thank you, Sarah. Sheriff Riggenbach.
I'll go with Christmas Vacation and Clark for sure. I'm a bit of a nerd with
The lights.
so on and so forth.
Excellent. Okay, thank you. Judge Bergeron.
That's what I was just going to say. I'm always the one organizing family events and getting frustrated when things don't go well. So Clark Griswold is me for sure.
Thank you, Pierre. Judge Salvaggio, 70s guy. So I can't wait to hear this one.
I've never given it much thought, but I would go with It's a Wonderful Life, George Bailey. I'm in the business of having my mind changed about a lot of things over a period of time.
Very good. Thank you. Joanna Sanchez.
I'm with Justin. Die Hard's a Christmas movie, but I'm the cop on the outside who doesn't face any of the danger but helps.
All right. Very good. Thanks. Justice Donnelly.
Well, you stole my thunder with the judge from Miracle on 34th Street. My father was a probate judge, and that's the type of judge that was in that case. So thinking along those lines, I'm going to go with the political boss that tells you, the judge, that if you go out there and declare that that's not Santa Claus, the only friend you'll have is the district attorney, and the response from the judge is, no, the district attorney's a Republican. So, other than that, we just watched A Year Without a Santa Claus, so I'd go with Snow Miser too. So,
all right. Thank you, Michael. John Martin.
Well, I'd like to be the defense attorney in Miracle on 34th Street who came up with a crazy federal supremacy argument to get the judge off the hook and keep the political boss happy.
There you go.
That's
Very
right.
good. Love that analysis. Tim Young.
Oh, it's a strange tie for me. I would go with Love Actually, strangely, because I'm a hopeless romantic, and I would view myself, I guess, as the Colin Firth character.
Okay.
The other one is Elf, which I think is the greatest Christmas movie ever made, potentially. And I would picture myself as Papa Elf in that one.
Papa Elf, is that, who was that? That's not Will.
No, gosh, no.
Who is that? Was that Bob Newhart? You're Bob Newhart.
That was Bob Newhart's character.
Yeah. All right. Very good. Thank you, Tim. Elizabeth Miller, still on. You didn't get out.
I would say I grew up watching A Christmas Story in the 24-hour marathon, and I would say I'm Melinda Dillon, the mom, always trying to protect the kids and maybe change some of the facts and not cause any disruption during the holiday season. Plus, I'm from Cleveland, so that story is near and dear to my heart.
Very good. Thank you. Mark Godsey.
I think I'd also be George Bailey, and It's a Wonderful Life. He focused on friendships, and then he needed his friends in the end.
Mm-hmm. Very good. Thanks. Meredith O'Brien.
I would be the movie Scrooged, and I would be the I think her name's Claire, the kind of love interest protagonist character against all the negativity of Bill Murray.
Mm-hmm.
And yeah, just a good-hearted movie in that way.
Very good. That's a good one. I've not heard that one before. Michael Woods.
I'd have to go with Bad Santa Judge, because things get a little stressful at times. And
did you say Bad Santa?
Yeah.
Oh my. Okay.
I had to pick something that no one chose yet. So
there you go. All right. You want to pick a character there?
It would probably be Santa. Stress gets to me at times. So
is that Vince Vaughn? Was that played by Vince Vaughn?
That was, what is his name? He was married to
Billy Bob Thornton.
Yes,
oh, Billy Bob Thornton.
Yes.
Thank you. Yeah. All right. Well, thank you very much. That's a new one too. So Pierce Reed, you're up, Pierce.
I would say that I am the spotted elephant in the Island of Misfit Toys in Rudolph Reindeer. And if you knew me better, it would not require an explanation. I'll plead the fifth.
Okay.
And my boss is here, so, I need a job for Christmas.
There you go. Thank you, Pierce. Andy Wilson, your boss is not here, so you're free to say whatever you want.
I'm free to say whatever I want then. So hey, I got to go with Justin and the others who said Die Hard. And of course, I'd be John McClane, because what kind of red-blooded American doesn't want to thwart terrorists and save Christmas? So that's who I would be.
Very good. Thank you. And I believe Senator Gabarone, Teresa, you're last on the hit parade this morning.
Can you hear me?
We
can you hear me now?
Yep.
Okay, I was muted. Sorry about that. Actually, I'm also It's a Wonderful Life, but not George Bailey. I think of myself more like Clarence.
There you go.
I like to think outside the box to solve problems and help people through difficult times. And so I'm kind of more of a Clarence gal.
All right, very good. Well, thank you very much all for indulging me a little bit with this holiday free for all. Appreciate it very much. On to we're going to take this hour, talk about some things as the agenda reflects before Maurice is available and listen to his presentation. He did indicate, by the way, that he's willing to stay as long as and participate in questions as long as anyone would have questions for him. But we have the second hour blocked off for Mr. Posley. Let's talk about the second item on the agenda is meeting dates for 2021. We don't have a hard date by which our work is to be completed, although in my mind, I think we need to have it done in presentable form back to the chief by May, which is a pretty aggressive, essentially 5 months. In looking at our calendars, we've been meeting on Thursday, as you all know. but it's becoming problematic with the legislature, and I want to be prudent about not excluding the legislative representatives starting after the first year when they will be back in session on a regular occurring basis. So I want to move our meetings to a Friday. And as I look at my calendar throughout January to May, my Fridays are problematic in the sense that if there is no one fixed like the second Friday of every month. So I would like to see and take a poll of the attendees presently to see whether or not any of you are aware of conflicts for January 15. I know we indicate on item 5 that our next meeting is January 7th. I actually happen to have a conflict on that date. I'm not sure why I told Justin to put that in there on the 7th, so that's my error. I apologize. I'm hoping we can have our first meeting in January on the 15th. Anybody have a conflict that they're aware of presently?
That would be the same time, 10 to noon?
Yes, so it's always 10 to noon. I think a 2-hour block we will use. We'll meet, so the first time will be January 15th. Depending on how much we get accomplished in January 15th, and we'll talk about that in a moment. You know, I'm going to try at least once a month. We might have to double up in February and March just to complete the work in time for a May presentation. But let's see if we can get the 15th down. Anybody have a conflict on that date presently? All right, Justin, so let's mark it down for the 15th, all right? Next, we are continuing to meet by Zoom. The Chief Justice has extended the work at home and maintaining that's the oral arguments of the Supreme Court will continue by way of Zoom. I think it's through March, is it not, Justin?
Yes, as of right now, it's through March 31st.
So we will follow the lead of the chief, and to the extent that there are no in-person meetings being permitted, we will continue to meet by way of Zoom. If things develop and in-person meetings and the Judicial Center is open back up in the spring, we will convert to an in-person meeting, and hopefully by the time we conclude this in May, that we will be able to at least assemble once collectively in Columbus for our meeting. But in the interim, all of these meetings will be by Zoom until further notice, okay? The first meeting in January, January 15th meeting, if you remember, we split up into the 3 categories. As I thought through how to proceed in beginning and completing our work, the January meeting will begin with an examination of the rules, criminal rules, statutory rules, procedural rules, with a focus on making modifications or corrections or additions. So we will address those points in the presentation that each of you have submitted to us and that we previously provided. I think what we'll do is Justin will send to everyone copies of all of them so that you know the subject matter for which we will be discussing. And I expect just engaged discussion. If there's additional work, any of you research that you are interested in knowing in order to be better versed or fully versed in some of the specific items that will be up for discussion in January, please send us, Justin and myself, email so that we can see the extent to which we can provide that additional research for you in preparation of the January meeting. And then as we collectively work, and it would be the majority of the committee vote would move forward then in the passage of recommendations to the chief. We would move on to next items. Second category, the second month would be then, I think we'll do the training and education component, with the last being the method of how we want to organize, be it by way of statewide organization, county-wide, with rules, or a conviction commission, much like is used in North Carolina. I think that significant discussion should be held to the end once we get a better sense of rule changes and procedural corrections and training. So that's how I envision proceeding in between now and May. Any comments, questions, concerns? How about that? Seems logical. Okay. All right, great. Speaking of presenters, let's item 3, discussion of Larry Krasner and Patricia Cummings' presentation. So what do y'all think? Who wants to start? Judge Salvaggio.
So to the extent that my comments have limited applicability to the work of the task force, I'll accept it. But I've had some cases on my docket within the last couple of days that have made me reflect a little bit on what our presenter had to say, and it's in particular his comment that he believed that all criminal cases should not have finality. Now I'm paraphrasing him. But, you know, the concept of finality in a criminal case, I don't think is as broad a stroke of a brush as he presented it. The Supreme Court just 2 months ago in State versus Henderson talked about the finality of judgment with regard to void and voidable sentences. And the double jeopardy clause with regard to allied offenses of similar import and also when people can, you know, be prosecuted a second time, speak to the question of a finality of judgment. So I understand with regard to claims of innocence that we all want to do it right. And I understand that we want to give those who have legitimate bases for exploring their innocence that opportunity. But I do have a little concern that we are positioning ourselves in a state of thinking that every criminal case is entitled to a concept that the judgment isn't final, because that's not true. I mean, that's not how the system is set to work. And so I'm raising this just as an issue based on it. It almost seems like we accept there is finality of judgment in certain respects in criminal cases. And I guess I'm just throwing it out there because our presenter took the position, I thought, that there was no finality.
Okay. Anybody, John?
I appreciate being able to speak right now because I do want to follow up on Judge Salvaggio's remarks, in part because I was the attorney on Henderson. So just by way of background, Henderson was a case where in 1997, my client has committed a murder and the judge says, you are a despicable human being. And by the way, I'm not questioning the validity of the judge's comment in that regard, but went on to say that you're going to get 3 years for the firearm spec consecutive to 15 years for the murder. Have a good day. Total of 18. The judge forgot to say 15 to life. Now, as a result, we come back in 2018 and we say when the state comes back 3 days before release and says that sentence is void, it was illegal, judge, we need you to give a new sentence. And it's the defense who argues, no, it's too late. And the Ohio Supreme Court actually took it further than we argued it and said, the state had 30 days to appeal back in 1997. They missed their opportunity, 99, whatever it was. They missed their opportunity, and therefore it's too late, and there has to be finality. So just with that as a backdrop, I agree with Judge Salvaggio that finality is something that has to be part of the system, just as alacrity has to be part of the system, that, you know, justice delayed is justice denied. But, and this came up in the oral argument, because I remember it was Mr. Justice DeWine said to me, isn't this an easy case? They had 30 days to appeal. They didn't. Therefore, it's over. And after I tried to answer that question, the chief came in and said, but what would have happened if the sentence had been above the statutory maximum? Does that mean finality would preclude the possibility of helping a defendant who is serving more time than the law provides? And, you know, it was a quick discussion in that case. It came up in another case, and the question becomes this. Finality is a value. And I agree with Judge Salvaggio that it is not a value that can be discounted from either side. But at the same time, finality cannot mean that if a judge gives 20 years for the theft of a loaf of bread when it should have only been 6 months, that we can turn around and say, you missed your opportunity to appeal and therefore have a good 20 years. Somehow we have to balance those two aspects of all this. How do we weigh finality against fairness, against due process? And from my way of thinking, it may very well be that what we need to say, and what I think we do need to say, is that there is a double standard, that finality against the state has certain aspects, priorities, values that must be weighed. But that finality, when it comes to prejudicing or putting the defendant at a disadvantage, takes into consideration an extra element, a constitutional due process element that the state does not enjoy. The Bill of Rights does not protect the state, but it does protect the criminal defendant. And so I see Judge Salvaggio's point. At the same time, from a defense perspective, and I don't mean this from a defense attorney's perspective, I mean this from society's perspective into how we look upon the rights of a criminal defendant, finality is not equal for both the defense and the prosecution, because the defense has an added right that the state, the sovereign, will never have, and that is the right to due process against the sovereign. And so therefore, those are going to be part of, I think, what's going to be part of our discussion. I do have another point to make, but it's unrelated to this, and so I'll yield in order to let anybody follow up on what I'm saying right now.
John, Justice Donnelly, we'll hear from you in a minute. It's an interesting perspective. I did not realize you were the attorney on Henderson. And what's interesting is that the Supreme Court in Henderson clearly did not recognize this distinction. And the ruling is pretty straightforward and simple, which is finality is finality. If it's void, it's void. You have 30 days if it's voidable, and really pared back what constitutes void and voidable. So it'll be interesting to see if there are cases, I'm sure they exist somewhere, for the Supreme Court to address that particular issue. Justice Donnelly, you had your hand up next.
Yeah, and I appreciate Judge Salvaggio bringing this up, because I think that concept of finality represents what we're up against in trying to effectuate real needed change. What I took from Mr. Krasner's presentation was that there has to be a value greater than finality in our system, and that's accuracy. And everybody should be on board with that, including prosecutors, because if you watch that Michael Morton documentary. And I urge everybody who has not seen that to watch it. You know, if they would have focused on accuracy in the post-conviction stage, they might have prevented a murder from happening. And that's why accuracy has to take I believe, a higher role in our system. But I think that finality represents a fear. For 14 years, I valued finality. Every case that resolved, I took great satisfaction so we could move on to the next dispute. But there's also this myth that we have to deal with that Jim Petro eloquently articulated in his book about wrongful conviction. And that's the myth that everybody that gets convicted in our system claims actual innocence. And that's just not true in my experience. And for 14 years, I read every single letter from every individual who went through the process in my courtroom from prison. And for a long time, I would go out and I would talk about wrongful conviction. I'd said, I've never received someone, a letter from someone who represented that they were actually innocent. Now, 7 years into my term as judge, that changed. One day I received a letter from a grandfather who said that his son, who went through the process in my courtroom, cries himself to sleep every night, an innocent man. And I quickly went to the computer, looked up the defendant's name, and saw that it was a murder plea and an agreed sentence of 15 to life. So what I did was I told my bailiff to immediately order back that defendant back from the system. And I ordered all the parties to convene for a hearing to address this. And I subpoenaed the grandfather who wrote this letter. And because I didn't know too much about the facts of the case, it was a plea and it was an agreed sentence. And we had the prosecutor lay out all the evidence that was, had it gone to trial, would have been used to convict him. The defense lawyers, with Mark Stanton, stood very well respected, zealous defense attorney, stood up and said, "Judge, we can't go into any into any private discussions that we had, but we were fully prepared to try this case if necessary. We were satisfied with the discovery we received, and we negotiated a plea in which there was a clear benefit. He could have received life without parole. He received 15 years to life." And when that was all aired out, I asked the grandfather if he'd like to say anything, and he said no. And I was satisfied that that conviction had integrity. And I ended the hearing. I told the defendant that I would entertain a motion to vacate the plea. That I wouldn't necessarily grant it, but I would hold a hearing on that issue. And he went back to prison, and I never heard from them again. And that experience taught me something. It took 20 minutes of my time and to address that claim of innocence that turned out to be baseless in this particular case. But it protected the integrity of the prosecutor's conviction. Prosecutors were satisfied. And it just, this issue that finality has to, take precedence. What we're talking about is putting some transparency on these claims that, when someone claims actual innocence and tries to file a post-conviction motion in prison, and they tell them right off the bat, don't expect to get a ruling on this for a year, and that's just should not be. I mean, we have to figure out a way to vet these claims of actual innocence and put the light of transparency and treat them with the same urgency that we treat people who are presumed innocent and indicted. And that's my thought. And people just, if you look at how these people have to fight, the people who have eventually been exonerated, it's just something that should not exist in a system that's designed for truth and accuracy. So that's my thoughts on that.
Thank you. Mark, Godsey, and then Tim Young.
Thanks. So yeah, I agree with Judge Salvaggio that finality is important. And, I've been litigating these cases in the state for 20 years. And I would not agree if I didn't interpret Krasner to say that there should be no finality in any case. But to the extent that he said that, I wouldn't agree with that. Because I think there needs to be sort of a presumption of finality. And so we submitted, the Innocence Project submitted a memo with some just very specific little tweaks and rule changes.
Mm-hmm.
And those represent areas where we've run into where there's that sort of gaps in the ability of somebody who has a legitimate claim to bring that forward. And so those would be instances where I would say we need to sort of update the laws or something, because there are instances where there's colorable claims of innocence where finality has too much weight. And so, Judge, you and Salvaggio, you indicated your comments wouldn't apply to somebody who has a legitimate claim of innocence. I think we're on the same page. But in doing this work for 20 years, we found some gaps in the law where people who do have a colorable claim have come up to these procedural bars that make it difficult or impossible in some instances to put that claim forward and get it fairly heard. But I would never say that all criminal cases should be unfinal. There needs to be a process, but there's some instances where the process isn't properly built to reflect changes, what we've learned over the past 20 years and things like that. So our suggestions were, if you look at that memo, are just some minor, I would call minor tweaks to some of the rules. And I don't want to get into all that now. I guess we're going to start doing that in January.
Mm-hmm.
Yeah. So thank you.
Thank you, Mark. Tim Young, you had your hand up next.
Thank you. I hope I'm not just repeating everybody. I just want to clarify first and foremost what John Martin said. The vast majority of people in prison are not claiming innocence. We're not going to see some floodgate of claims if we change some of our rules. I think the second piece I just wanted to emphasize, and when I say that, please understand, I mean, we're an office that does receive dozens of letters, hundreds of letters a month. Only a small fraction are actual claims of innocence, and that's why we started our Innocence Project, the non-DNA project. But the vast majority of those people pled guilty. 98% or better in many jurisdictions, and very, very few of them will ever challenge. I think the second piece is, I just want to emphasize, this isn't a choice between finality or not finality in all cases. This is a bright group of people. We can define narrow exceptions that don't open this to needless claims and don't flood our courts with waste of time motions or hearings, that we can define this for colorable claims of innocence that get you in the door and undo that finality stoppage. It's that we're looking to create a limited exception, not a complete exception to finality. Most cases will end as they do now. But it's not an either or choice. It's how do we define the exceptions for these gross miscarriages of justice. Thanks.
Thank you, Tim. Anyone else? I just want to remind everyone, our first substantive discussion was actually something that you raised, John, and that is, are we dealing with innocent people? Or are we dealing with people who believe they were procedurally disadvantaged? And as a group, we've already decided we are looking at colorable, and I liked how Tim just characterized it, colorable claims of innocence. That constrains the work of this group, with one exception, because the chief was, I think, salient enough to understand it's not just conviction integrity, and therefore, how do we deal with those culpable claims of innocence when presented, but also looking comprehensively at the post-conviction practice. Okay, and that's where I think it's important that we enhance finality. We don't jeopardize it. When we view the post-conviction practice and rules and constraints in Ohio and recognize that there is some problem with that, and there are some modifications that effectively can produce, I think, more lasting justice than just and therefore complete justice, which is the equivalent of finality as well. Everyone likes talking because it's the buzz subject, conviction integrity units, right? It's the prosecutors, that's all they focused on when they said, this is our problem, we're fixing it, we're changing our model rules, we'll manage our own affairs, right? And I think they're wrong when they do that because they're just part of one player in a system. And they ignore the reality of the other players in that system that play crucial roles as to whether or not that conviction should uphold as it is, or if there's some other post-conviction process that we should employ because it's the better way to approach it. I mean, before Claire's Gideon, we as a society never thought people should have the right to counsel. That's now commonplace. Like, we don't even think of that. It's like turning on a light switch, right? So the point is, as we view improving the system of justice that is being dispensed in a post-conviction world, right? If there are changes to that enhances that ability to make it a more fair or just system, I think we're obligated to try and improve that. If it impacts on a conviction integrity process, so be it. But they're related, but they're not necessarily hand in glove, if you understand what I'm saying. So I do think, and I was surprised that Larry didn't talk about very much what his new effort is, which is the reviewing of existing sentences on his own, where he's going back and attempting to undo sentences that have not been appealed or that there are no pending petitions. And he's trying to say this sentence is too onerous and therefore trying to petition the court to reduce the sentence. That's his current foray into, I think, expanding how he views establishing the integrity of particular convictions. That's a far more aggressive approach than merely trying to provide a mechanism by which colorable claims of innocence are properly vetted, timely vetted, and properly disposed of, which is what I think what we're trying to accomplish. So anyway, anyone else in terms of the presentation?
Judge,
yes.
If I could, one other observation, because this is something that's come up in some of the written materials that everybody's been submitting. The Pennsylvania approach, if I call it that, is obviously a county by county matter. I mean, the Philadelphia district attorney said he's pulled out of his statewide district attorneys association because of disagreements with them on particular issues and the like. And I think that speaks to one issue about conviction integrity units that are within prosecutors' offices, and that concerns me is that if in fact, and it follows up on Judge Zamuta's comments, if in fact conviction integrity is left solely to prosecutors, and don't get me wrong, having been a prosecutor, I've never met a prosecutor who wanted to go to bed at night saying, yeah, that person was innocent, but I convicted him anyway. And so, in my 10 years. And so, but the point is this, if we leave it solely to the individual prosecutors' offices in each of the 88 counties, we run into the possibility of marked disparity in justice throughout the state. And to be quite blunt about it, marked disparity that may very well run along certain racial lines or political lines, because Larry Kudlow can get elected in Philadelphia as the district attorney as a reformer. LA can elect a reform-minded district attorney, as they recently did. All right. But let's be candid about it. Okay. That kind of approach might work in a place like Cuyahoga County. Okay. But I really can't believe that, without naming names, there's a number of counties in this state where a prosecutor who came in and said, I'm reform minded, had better not give up his day job, because the candidate better not give up his day job, because it's just not going to hunt.
Pierre, did you have your hand up?
Yeah, I kind of share some of those thoughts, which is that as interesting and inspiring as some of what they're doing in Philadelphia is, I just don't think that, looking at the map of Ohio and thinking about the 88 counties, that there's going to be any sort of groundswell of support anytime in the near future to implement CIUs in even more than a fraction of the counties. So I think as we as a committee think about like, what are the end product recommendations? If our recommendation was, we think prosecutors should house a CIU unit in their offices, I just think that's going to be ineffective in this moment. So I think our challenge is, are there other vehicles to maybe get to the same place, but institutionally would have to be structured differently? Because I just personally don't think it's feasible to say that we're going to get a bunch of counties to suddenly sign up and do this. So I had some similar reactions as John to that.
Interesting. Tim, you had your hand up. Did you want to comment?
Just very briefly, I completely agree with John and the judge that this isn't going to happen in 88 counties. I don't think it has anything to do with reform or not reform minded. I think it's got to do with the fact that the vast majority of Ohio are rural counties and they don't have the resources. This is a resource problem to set this up and have a formal process and a review team and the ability and the time, the training that's required. It's a resource problem. It also doesn't make economic sense to try and fund those resources at each and every county rather than some potentially regionalized or statewide process. We'll just never achieve this in 88 different places. It doesn't matter how much money we throw at it. It's just never going to occur. And it's little to do with the politics, I think, of those people who would choose or not choose to do one. It's simply we have very small places. We have counties with 25, 30,000 people in a couple of places. They're very, very rural.
It's interesting because Larry's presentation and Patricia's presentation in particular clearly believe that the solution lies on the county level. Even though they recognize that disparity that the three of you have articulated and talked about, and has resulted in, it's not, I was going to say patchwork, but it's not even a patchwork process. I mean, there's even though there's 60, approaching 80 now nationwide, that's such a small percentage of jurisdictions that have actual CIU units established. And what's really interesting is the lack of any other methodology of examining conviction integrity issues, but for within the constraints of the local prosecutor's office, with the exception of North Carolina, and no state has adopted a statewide through the state attorney's office, except for Connecticut, and that's because that's how they're structured. Their DAs are all, employed by the state DA, who's the elected official. So how they're organized as a court is what provides the functionality of that. So when we get to that, and this is a meaty discussion, so when we get to that third prong in a couple of months, the integrity of lasting change hinges on how we decide to best implement whatever changes we're going to recommend to improve our lot in Ohio, recognizing that we are home rule at 88 states, 88 counties, and we're not going to change that. But given that structural recognition, how can we effectuate better opportunities, better guarantees to enhance the potential of effectively allowing culpable claims of innocence to be more expeditiously handled in the state? So that's a good way of putting what our task is going to be. Justice Donnelly?
Yeah, I agree with Tim Young's observations about resources and lack of resources, but I think we also have to admit that we have to discuss ways to effectuate culture change, because I don't think all 88 prosecutors would be up for starting conviction integrity units in their office. I had a young extern who went to apply in a rural county for an assistant prosecutor, and the discussion of this task force came up during his interview. And he was told by the prosecutor in that county that he disagreed with the need for this task force. And the young intern asked why, and he said, because we already have conviction integrity units. They're called courts of appeals. That's what his response was. So that's an attitude that's out there that we'd be up against if we tried to establish this on a county. And this makes me want to learn more about the states that have an independent statewide commission, because I think that way you could get that independence that Larry Krasner has given his conviction integrity unit. But the success of his conviction integrity unit, I took from the presentation, depends on how long he's there and his personality, and whether his successor is going to adopt the same philosophy.
This is Teresa Gavarone. If I can chime in for a second, listening to the conversation, lack of resources and everything. I mean, if there were going to be a CIU unit at each county, couldn't there be, certain public defenders who are specially trained? They get CLEs for the training, and that would, do their public defender work, but also focus on the conviction integrity. And then it'd be at each county level, and maybe have some overseeing, authority at the Attorney General's office that kind of keeps things consistent. I mean, it's something like that. It really wouldn't take that many additional resources, because we already have, public defenders' offices and things like that. But would just give specialized training through specialized CLEs, maybe developed through the Attorney General's office, and that would also focus on conviction integrity when there are claims that, hey, I am innocent of this charge, and they could look into that. Is that something that would help, maybe accomplish this goal without, a whole lot of additional resources?
That certainly is on the table, Senator, and will be discussed both in the second section, which will be the training and education changes that we will be recommending, if any, and why I think it's important to make the ultimate recommendation, which is the structure of how to proceed relative to CIUs and the colorable claims of innocence. At the end, once we fix the process, which is the rules and statutes, and we enhance so that the participants, the lawyers on both sides, on behalf of the state as well as the defense, as well as the investigators and law enforcement, that they're all properly trained in the sciences that have the potential of eliminating a wrongful conviction, such that it would reduce the necessity of creating CIUs all the time if they're only going to be convicting people that aren't innocent, if that makes sense. So it's on the table. We certainly will be discussing that option or those options as we move forward after the first of the year. Anyone else?
Great, thank you.
Sheriff, we haven't heard from you.
So as a sheriff of a small rural county, 28,000 people.
Which county, Sheriff? Just to remind.
Van Wert County, Northwest Ohio.
Okay.
Certainly resources come into play with anything in our situation. But I would want to say this, and I'm certainly not speaking on behalf of my prosecutor, but I take very serious my responsibility to do the job that I'm elected to do for our citizens. I believe our prosecutor does the same way. And I would not want the legitimate concerns that have been expressed about potential lack of resources in rural, smaller counties that might prevent CIUs from happening. I would not agree with an approach that takes away the ability of the local county to be able to get established a CIU. Certainly personnel and the things that would go into that have to be taken into account and can be a concern. But I think it's important for an avenue for counties such as myself to be able to try to figure it out and put something together to be able to do this. Not everybody will be able to. I think we would all agree, and it's probably been stated more than once, not everybody's going to want to. I guess I'm speaking more for myself. I would not want the opportunity to be taken away from our county to try to do this, to figure out a way to do this. The senator's comments, resources and the training, and then having something maybe through the Attorney General's office. Certainly this is not identical, but what I would share is when I have a large crime scene that is beyond the resources that I have within my office, I can contact the Attorney General's office to assist in that part of the investigation while utilizing my personnel in-house for other aspects of the investigation. And so it's an avenue on larger scale events that my office can still handle a significant portion of that investigation, but pulling resources in this example I'm giving from the Attorney General's office to get to the end result of the most detailed and thorough investigation possible. And I would, speaking for my county, certainly would hope to be able to have a similar opportunity with what we're talking about. I think ultimately our responsibility is to get it accurate, to be accurate, and would certainly want my county to be in a position to be a part of doing that, to make sure we meet our duty to the people in our community, that we are accurate and get it done right.
Very good. Thank you, Sheriff. We only have a minute before. So John, was there, Joanna, did you have your hand up? No? I want to give everyone an opportunity if they haven't spoken. If you didn't, John, go ahead.
Okay,
John.
yeah, I don't want to step out. You've been very indulgent. Just a quick observation. It's hard. This is not definitive, but it's hard to get excited about the likelihood of success on a county by county level through county prosecutors' offices when I'm looking at a Zoom conference without a single prosecutor.
Well stated. All right. So thank you for the discussion. It's 10:59. Michael or Justin, how are we dealing with?
I just got an email from Maurice. He asked if we're ready to log in. I told him to log in now, so it should be in a minute or two.
All right, very good. We'll continue our discussion in January and add this presentation to that.
Judge, apparently he just emailed me. He's having technical difficulty. I'm going to try and get him on. Give me 1 minute.
Yeah, no problem. We do run through prior to our task force meetings with the presenters. So I know it was working before today. How are we doing, Justin? Or Michael?
I sent him the link again to try logging in. So hopefully any minute now. Oh, here we go.
Here we go. How are we doing, Justin?
He's here.
Hi, Maurice. This is Judge Zamuda. How are you?
And to try logging in. So
I made it.
Oh, here we go.
You made it. Maurice Posley, welcome.
Hi, Judge.
Great to see you again.
Great to see you. Sorry about my, I'm dating myself, but you know, I remember the growing up watching the guy with all the plates on Ed Sullivan
Hi,
spinning.
Maurice. This is Judge Zamuda. How are you?
And to try logging in.
Justin, we have this.
I'm getting feedback.
I made it. Oh, here we go.
You made it. Maurice Posley.
Wait a minute.
I'm guessing somebody has the YouTube stream possibly.
Yeah, I think,
streaming as
Maurice,
well.
you probably have the YouTube stream open because you indicated you're watching it. So close that stream.
I just did. I think that probably, I was saying the guy with spinning all the plates on the sticks and like this, and I can do one plate. And so I apologize.
See, so now everybody knows that, and given the judges that are in this group, we have to be time delayed because you never know when one of those judges is going to go off, and you know we don't want the FCC coming after us because of comments that are being made in the task force. So that's why we have that delay. No, I'm joking. Anyway, it is my pleasure to introduce our guest presenter today, just so that everyone reorients. A couple of months ago, a request was made, can somebody give us a presentation about the exoneration cases that are particular in Ohio? I offered, because of my familiarity and having met with Maurice Posley and talked with him previously, you know, the opportunity that maybe they could present with about what they do in the National Registry of Exoneration. And so we've invited Maurice to speak here. We attached his biography. It is with great honor that I get to introduce him. He's a Pulitzer Prize winning journalist. I didn't realize that he was the author of 5 nonfiction books. And he cut his journalistic criminal justice teeth in Chicago, which is a great place to do that, right, Maurice?
Yeah, it sure is.
and has found his way to California. Volunteered with the California Innocence Project back in 2009, and now is one of the researchers that helps write case summaries on exoneration cases and investigates those cases before they're vetted to be added to the registry. Beyond that, and how I first met Maurice is he also teaches and lectures and presents, and he and I were actually, I think you invited us to come and present at John Jay College of Criminal Justice a couple of years ago, and that's where we first met. We've been maintained a rapport of contact ever since. And it's with great honor and pleasure that I introduce Maurice Posley, who's agreed to give us time and give us a presentation. And Maurice, I just want to make sure, as before, do you prefer questions through your presentation, or would you like us to hold questions until you've completed?
I don't mind taking questions as we go along. It's just perhaps someone could help monitor those questions as they come in and just say, yo, supposedly take a question, you know.
Justin and I will do that. Would encourage task force members to use the chat function of the Zoom if there are particular questions that you would like raised, and we'll address them in a timely fashion by doing it that method. Without further ado, Maurice, the floor is yours. Welcome.
Well, great. Thanks very much, Judge. And thank you, everyone, for indulging me. I'm going to share my screen and go through some slides. Let's see here. Does that work?
Here we go.
Okay. I wanted to tell you a little bit about the history of the registry and how it came about. Excuse me. More or less, you know, tell you what it contains, how it works, what you can find in it. At the very end, I would like to just take a couple of minutes to go live on the website and maneuver around a little bit. But it was originally conceived as a book called The Encyclopedia of Exonerations by Rob Warden, who was the executive director of Northwestern University Law School's Center on Wrongful Convictions. And at some point, he realized that as soon as it came off the printing press, it would be out of date. And so he teamed up with Sam Gross, professor at Michigan Law School, and began collecting these. Rob had collected quite a few. And at some point, they decided to make it an online database. And initially, it was just going to be data that could be manipulated, with some of it public facing and some of it internal, mostly for research. And then almost as an afterthought, they decided to add narrative summaries of the cases. And so it went public in May of 2012 with about 800 cases. It now has, has officially 2,699. We're about to add the 2,700th case. It is now a joint project of Michigan State Law School, Michigan Law School, and University of California, Irvine Newkirk Center for Science and Society. It's a three-university project, research project. We count them and we tell stories. Where do you start with really is to define it. And I know that it's been talked about a little bit. I've watched the previous presentations, but generally it's when someone is cleared of the consequences of their conviction based on new evidence of innocence. And the term new really means new to being presented in the case. And I say that because sometimes there's evidence that's favorable evidence of innocence that is known by, say, the defense is not presented. So in a certain sense, it's not new. It's just that it's new in terms of being presented to the case. The full definition is on the website. It's under our resources tab. But essentially, you have to be, what we do is we rely on what others do. By that means we don't decide if someone should be in the registry. We decide if they meet the criteria. And the criteria is they have to meet most of these parts: declared factually innocent by a government official or agency with the authority to make that declaration, or, as I said, relieved of all the consequences of the criminal conviction by a government official or a body with the authority to take that. This could be a complete pardon by a governor, an acquittal, as long as there is this new evidence. And I'm stressing that because one of the things, if you get your case reversed because of insufficient evidence, those don't qualify for the registry unless there is some favorable evidence that was not presented at the trial. And we say it has to be, it doesn't have to be an explicit basis, but it has to be known. Again, here's just a little bit of a summary. You have to be convicted, you have to be cleared, there has to be this evidence of innocence, and this can be impeachment evidence that's favorable to the defense, be impeachment of a prosecution witness or of the prosecution, or it can be direct evidence of innocence. One of the things people say, how do you know if somebody might actually be guilty and still meet your criteria? Well, my answer is we don't always know. We keep out more innocent people than we let in guilty people is sort of the way I phrase it. But if there is what we call unexplainable physical evidence of guilt, that's a DQ, even if you meet the criteria. And an example of that is a drug case where someone will say they might get their case reversed because, say, impeachment evidence of the police officer was not disclosed. Well, if there's no explanation that is consistent with innocence about the suitcase full of cocaine in the trunk of the car, that's unexplained physical evidence of guilt. And so you don't make the cut. I mentioned the certificate of innocence or a declaration of innocence because there are some cases that are reversed on the basis of insufficient evidence, where defendants later obtain a certificate of innocence or a declaration of innocence. This sometimes comes through the compensation process. And Ohio has some of those cases. It's not a lot, but it's a few where there is not new evidence of innocence, but there is the declaration of innocence. We don't include people who take Alford pleas. If you're acquitted at your retrial and the evidence doesn't change, sometimes you see cases that get reversed because evidence was allowed in through the prosecution that an appellate court says that shouldn't have been allowed. And so we need to do a redo. And without that evidence, and as defense lawyers frequently tell me, my cross got a little bit better the second time around, but the evidence doesn't change. If you're cleared of some but not all the charges that are associated with the course of action in the case, for instance, if you're convicted of murder, kidnapping, burglary, and robbery, and eventually you get cleared of everything but the robbery or the burglary, that's still part of the same course of action. And so even though you might be meet the criteria for the murder, you're not going to make the cut. I had an editor, I spent 25 years at the Tribune, and I had an editor who used to complain, and this is not a new phrase by any means, about being nibbled to death by ducks and don't bother me with repeating things. And I've watched John Holloway's and presentation, as well as Patricia and Larry Krasner's, and I'm going to try to avoid repeating some of what they said so that you aren't feeling as if you're being nibbled to death, but I unfortunately may do a little bit of that. We have a fairly elaborate coding scheme that's behind the public face. We have more than 200 different coding categories. Some of the public ones that you see are along the rail here on the right-hand side that has state, county, the most serious crime, any additional convictions which they were cleared, the year of the crime, the year convicted, the year exonerated, the sentence, and so on. There is on the page, which I'll show you live, but this is a look at what we call the detailed view page. all those columns are sortable. So you can sort by last name, first name, age, race, state, county of crime, county, the crime itself, sentence, the contributing factors. There's a column called tags. And I'll talk about that in a minute. Each of the cases gets a narrative summary. Some are longer than others. When, as I said, when the registry was first launched and I started writing these, I'm a journalist. I'm writing for an online publication, so I'm not worried about trying to put a quart in a pint container. I've got an unlimited length of, and Sam Gross said, I'm sorry, 500 words is our max. Well, that really went out the window at some soon point, because some of these cases are extremely complicated. They're extraordinarily long procedurally. And if you really want to tell the story, you have to have a little bit more room than 500 words. We have some that actually approach the 4,000 word length nowadays. We code what we call contributing factors. Cases can have more than one. And these are the ones that we code: mistaken witness ID, false confession, perjury or false accusation, official misconduct, false misleading forensic evidence, and inadequate legal defense. I can talk a little bit about those, but the ones, inadequate legal defense is one that we feel that that is the one that has the most serious undercount, because there's often it's more of a sin of omission than commission. The tags column allows you to sort for these variables. Unfortunately, only one at a time. I wish we could do, but you can sort to find out the conviction integrity unit cases. Did an innocence organization handle the case? Was a jailhouse informant involved? So we get requests from the press all the time, and I say, you can find this on the website, and they say, no, we find it's easier to just call up and ask you how many cases had jailhouse informants. But you can go to that detailed view page in that and say, sort on the tags column for jailhouse informant, and then sort it by county or state, and see how many cases in your state or your county involved that had an exoneration involved a jailhouse informant. There's no crime case. There's shaken baby syndrome cases, which of course now are known as abusive head trauma. We have a page, it's called our Tableau page, but basically it's accessible from the front of the website that shows the map, and this is how it looks on the landing page back at almost 100 exonerations ago. But it's sortable by all the same variables on the detailed view page. Here's an example of sorting by state by looking at California, just by clicking on the state. Here's an example of showing female women exonerees. This is you can sort by contributing factors, crime, race, whether DNA was involved, guilty pleas. So you can look at state specific and it's sortable by federal and non-federal cases. Behind the scenes are coding. The public site is a fraction of the data that we code for every case. We have detailed codes for interrogations, in false confession cases, recantations. One of my dreams is to someday do a study on recantations, because I believe that it's a really important, one of the things that we see is that recantations, despite the long history of skepticism, there's a lot of recantations that are given some credibility, even by CIUs, innocence organizations, obviously, and courts. Official misconduct is one of those that we have a lot of internal codes, and we've been working, and in fact, just released in September a report on the first 2,400 exonerations in the registry that details the role of official misconduct in the exonerations. It's book length, I warn you. It took about 2 years. Sam Gross is the primary author, but it is the most detailed look at official misconduct in cases of wrongful conviction that's ever been completed. And as a consequence, or as part and parcel of this, and I'll show you this later, but on the detailed view page, we now have a separate column where you can sort by forms of misconduct and actors. It's broken down by police, by prosecutors, by forensic analysts, by whether it's withholding of exculpatory evidence, whether it's there's various forms that are all it's much more granularly available, where up to this point official misconduct as a contributing factor lumped all these things together, and it was really hard to tell what was what. When I do the live presentation on the website, I'll show you these drop downs, but there's an issues drop down that has several issues where we address in some length. And one of those is conviction integrity units. And when you click on that, you get a list of conviction integrity units that we have assembled. This was an easy task about 3 years ago. It's becoming we can barely keep up with it now. But it lists each one, their address, and the number of exonerations with a link to a sort that shows their exonerations. This is in part because we get a lot of requests from people saying, how do I get in touch with the conviction integrity unit? These are people who are family members. Sometimes they're defendants themselves. We get emails, we get letters. And so we try to keep that out there as a way. We have, there's 2 lists, those with exonerations and those without. The resources tab has all of our annual reports. It has some graphics. It has links to, say, the misconduct report. We did a report a couple of years ago on race and wrongful convictions, looking at the exonerations in the registry and the impact of race, and they're all there. This is an example of some of the infographics that are out there. One of the things is that I mentioned before about how this couldn't be a book because it'd be out of date almost immediately. Our annual reports almost go out of date. People in the press will say, well, the National Registry of Exonerations reported 143 exonerations in 2019. Well, we did when we issued the report. We're constantly finding cases that happened in the past that we didn't know about, and we add them. We add about 200 exonerations a year. About 2/3 of those are in the year that it contemporaneous. The rest are ones that happened in the past that we find out about. Lawyers reach out. Defendants email us. I think my case qualifies for the registry. And some of them are right. And we add those cases. We have under the tab of browse cases, the different views and the different registries that we have. One of those, though, is the list of longest incarcerations. It's everyone who spent more than 25 years from the date of conviction until their date of release. 7 of those are from Ohio, and I'm sure some of those are people you're familiar with, particularly Ricky Jackson and the Bridgman brothers. But the current leader on the leaderboard is Richard Phillips. I mean, it's quite amazing to think of spending 45 years. And if any of you have seen the CNN It's like a mini doc. It's like 12 minutes on Richard Phillips. The guy is quite remarkable for having spent that long in prison. We have a database of pre-1989 cases. This is an addition within the last couple of years. It's more limited, in part because records are not easily obtainable. It was a residue at first of Rob Warden had been collecting cases back into the 1800s for his book on the Encyclopedia of Exonerations. It says on this slide 391, I think we're up to about 410 now, that things just come across the transom that you find out about. Here's an example of a case that's not in there. The recent movie about the Chicago 7 conspiracy trial. One of my fellow researchers watched it and said, that case was reversed and there was evidence that the defense tried to put in favorable of their case, and Judge Hoffman wouldn't let it in, and that was part of the reversal. Wouldn't that be considered evidence that would qualify this case? And you go back and you look at the Seventh Circuit opinion, and he's right. And so the ones who were convicted, not all of them were convicted, will be added to the registry at some point. We have just launched the groups registry, and we're still adding to it. It was sort of a soft launch. It's our third registry. And this focuses on groups of defendants that were tied together by a common pattern of systematic official misconduct in the investigation and prosecution of these cases. Essentially, these boil down to police corruption cases. Philadelphia has had, I believe, more than 1,000 cases dismissed. And I think there was some reference that Larry mentioned about police officers being convicted, and how you go back and there's a fellow in the public defender's office there, Brad Bridge, who's essentially made a career out of identifying these cases and bringing them in for dismissal. So finally, I get to Ohio cases. As of December 10 today, there are 85 in Ohio since 1989. There's one this year, and I'll talk a little bit about that later. There are 21 exonerations prior to 1989 out of 410. 3 of those were sentenced to death. And there are 2 in the groups. In 2007, there were convictions vacated and charges dismissed of 19 cases because of misconduct by a DEA informant, agent, and foreman in Mansfield. And in 2016, 43 convictions were vacated and dismissed as a result of police misconduct in East Cleveland. These are cases where there's no real individual re-examination of the cases to determine whether or not there may be an actual innocence case. And so these are ones, some of the groups that are going to be in this and already have cases that have been examined by conviction integrity units, for example. And I'll talk a little bit about that in a minute. And they will qualify for the primary registry. But there has to be some sort of individual examination of those cases, rather than just sort of saying, well, we've got all these cases, we no longer have confidence in them because of the corrupt conduct of these officers, and so we're going to matador them out of the courthouse. Of the 2,699, 3% have come in Ohio. 544, 20% of those pleaded guilty. 3 of those in Ohio pleaded guilty. The fact that there's 20% of the almost 2,700 cases involving guilty pleas, I think was a little bit surprising to me when I first started looking at these a few years ago, as we started accumulating more and more cases, that this is something that has to be taken into consideration, and people have to have a venue or a channel or a way back to the courthouse when they plead guilty. more than one third of the cases are no crime cases. And that's about 25, about a quarter of those in Ohio. These are cases where it was said to be an arson, but it was an accident. It was a shaken baby prosecution. It was based on a bad diagnosis or the science changes as we all know. There's some CIU cases that are no crime cases that I'm going to talk about in a minute. The no drug cases. CIU have 457, 17% of the cases, and it's growing. I believe for this year, I got a slide, I think, coming up for that, but almost half of the contemporaneous exonerations in this year, in 2020, are coming out of CIUs. 6 CIU cases in one county in Ohio, Cuyahoga. Innocence projects have been involved in 659. And, people tend to think of exonerations and innocence projects are synonymous. And they really, in one sense are, but in another sense, when you think that 75% of the exonerations were not the work of innocence projects. That tells you something about what the defense bar, public defenders, and private lawyers and pro bono lawyers are out there doing. Innocence projects were involved in 28% of the cases, 24 cases in Ohio. Looking at the types of crimes involved here, most of the Ohio sort of mimics the national statistics. Like I said, these are the ones that make up 88% of the registry cases, and they make up 87% of Ohio. Murder is always the number one. And the reason for that, in my experience, is because these are the longest sentences. These are the ones that gets the attention, particularly in death penalty states where there's an outcome certain that's potentially pending out there. And so when people triage these cases, in terms of, I'm speaking of innocence projects primarily, but these are the cases that get the attention. They're the ones that are almost sort of the hardest, that take the longest. But these are the people that are, potentially going to die in prison, if not in an execution chamber. Again, the racial breakdown is similar between Ohio cases and the cases in all the cases in the registry. Although, with such a small sample, 85, it's really hard to make significant comparisons. And the contributing factors, the statistics on the right are what the percentage of 2,699 cases. In looking at that, what stuck out to me was, of the 85 cases in Ohio, only 2% involve false confessions. And I don't know what that means, but I suspect that means that it's typically they're hard. If you think getting a guilty plea overturned is difficult, try doing it with a false confession, particularly if you don't have DNA. You talk about Chicago before. If you do a search, you'll find that a huge proportion of false confession cases come out of Cook County, and that's basically Chicago. Peter Neufeld from the Innocence Project in New York has said that Chicago is to false confessions what Cooperstown is to baseball. And he's right. But you look at these percentages and they sort of are right in line with what's happening across the country. We are aware of 72 conviction review / integrity units. 2 more have announced they're going to open early next year. It was interesting to watch John's presentation, and he had a number, and then I think Patricia had a number, and now I have a number that's a little bit higher, and it just shows that it's a little bit of a reflection of people coming into office, being elected, who have promised to do that, who say they're going to do it and have done it. But, you know, here we are, 33 of these units have at least one, but 39 have none. Some are pretty new. These take time to unravel. In Ohio, there's 2, as you know. Cuyahoga has 6 exonerations, and Summit, which came into being a year ago, approximately, has none. In 2020, we have 107 exonerations, and 44 have been handled by conviction integrity units. Almost the same as the number that innocence organizations have had, and some of these overlap. And what we see are the cooperative efforts between innocence projects and CIUs are increasing as these CIUs. As the innocence projects earn the trust of the CIUs, that they're not trying to pull a fast one, that they have a strong belief and they're advocating for their clients, but they're not trying to pull a fast one on the prosecution. That all they want is a fair shake at the table. It's interesting when you see some of the people like Patricia being brought in, who had great experience down in Dallas. Queens County District Attorney formed their conviction review unit last year and brought in Bryce Benjett, who had spent a decade as a litigator for the Innocence Project. And you know, the Valerie Newman, who's the head of the conviction integrity unit in Wayne County in Detroit, used to be the head of the state appellate defender's office. Those people are bringing not only their vast experience, but their awareness and their ability to evoke change in sort of the attitudes. It's really, as you've heard, important in terms of who you staff your offices with. This is a breakdown of the 457 exonerations handled by conviction integrity units. And those 2 top ones need a little explanation. Harris County formed a conviction integrity unit at about the same time that someone discovered that the email box where the crime lab was emailing all their lab reports on drug testing, people weren't picking up the reports. And it turned out that, and by this I mean prosecutors, and they weren't picking them up because the defendants had all pled guilty. And so there was no need. They didn't have any need to pick those up. And somebody started going through them, and they found about 500 cases where the report was no controlled substance found, or a different controlled substance was found, or a lesser amount of controlled substance was found. The vast majority of these cases were the result of field tests, traffic stops that resulted in a consensual search that resulted in a field test, and those are so notoriously bad. But you know, people come to court, they're in custody, and today's sale is you get 6 months if you plead guilty. And some of these people were repeat offenders, and Texas, as a number of states, as you know, is not kind to repeat offenders. And so off they went, did their time, and then suddenly they find these cases, and so they started unraveling them and vacating the charges. And they have to, in Texas, they had to actually find the people. Well, they couldn't find all of them, but the vast majority of those 144 are no crime, no drug cases. Did some of those people think they had drugs? Probably. But the fact is that they pled guilty, and there was no controlled substance according to the crime lab. you're aware of the big scandal, drug lab scandal in Massachusetts, and they are in the process or have dismissing about a couple hundred cases where, as a part of their audit in that case, in their review out there, they found a couple of hundred cases of people where the lab reports were negative and they were never picked up by the prosecution, therefore never disclosed to the defense, and people wound up pleading guilty. In Cook County, we have a corruption case of a police sergeant named Ronald Watts, who, with a crew of officers, preyed on residents of a public housing complex and basically framed them for possession of drugs, guns. They took their money. It was an egregious case of corruption that went on, and eventually the Cook County Conviction Integrity Unit began reviewing these cases. And I think Larry Krasner referred to a time when he was in Chicago, and there was a dozen or 15 cases dismissed in one day. And those were Sergeant Watts cases. The state's attorney's office would get these cases brought in by the lawyers, and exoneration project at University of Chicago Law School has taken the lead in this, and they would vet these cases and bring them in. The CIU would review them and determine whether or not these people were innocent, as they had long claimed to be, and then would come in and vacate them. Of the 109 Cook County cases, I think at least 80 are Sergeant Watts cases. And then you come to Dallas, and Patricia talked about that. And Kings County is where, D.A. Thompson, before he died, sadly, really revived that and turned it into a vibrant conviction integrity unit, and had sort of an outside review panel. One of the things that I thought was interesting was that they recently had an exoneration there where a primary witness for the prosecution had an extensive criminal record that had never been disclosed to the defense. And the prosecutor at that trial is now the head of the Conviction Integrity Unit. And so they really drilled down on that case. And really what happened was this person had been arrested under a different, had quite a record under a different name. And the prosecutor had, even a week before the trial, had asked for like an NCIC check, and it revealed nothing. And it was just a sort of a colossal record screw up that this was not disclosed, not known to the trial prosecutor, and not disclosed to the defense. And they, Patricia, I think, talked about this in the interests of justice. And that's what they did. They said, in the interests of justice, we feel that this case has to go away. And then you've got Wayne County, where Val Newman, as I mentioned, the former head of the Appellate Defender's Office, and then on down the line. But really, the vast majority here are by these units. As I said, 383 by just 8 units. That's 5 out of every 6. And the 33 units that achieved the remaining 74, that's about 2 on average, but one of those has 9, 2 others have 6. And I said 39 units have none. The one case in Ohio is not a CIU case. And I'm pretty sure some of the members of this panel, at least one, is familiar with this case. It started with a car accident, a rollover accident in 2008 in Hamilton County. And a car, it was an SUV, blew a stop sign and took off at a high rate of speed. And so a sheriff's corporal or sheriff's deputy was saw it and was following, and it, almost in front of his eyes, it went out of control, rolled over, hit a church. By the time he pulled up, William Campbell was on the ground. He was alive. Tina Hayes, the owner of the SUV, was in the passenger seat, and she was dead. Campbell had a blood alcohol level of 0.155. He had 6 prior DUIs. He had a lifetime suspension. And he claimed that she was driving. She dropped a cigarette and she tried to reach for it, stepped on the accelerator, and lost control. So he went to trial in June of 2009. And one day after the trial began, a mistrial was declared when a second set of keys were found in the pocket of his shorts that had been taken from him at the hospital. A set of keys was found in the ignition. So it was a question that raised a question that the defense said this is favorable, and so we want to redo. So he went to trial a second time, and the evidence included analysis that a hair found in the passenger side door was Hayes's. The deputy who was first in the scene said that Campbell's shoes were on the driver's side floorboard. DNA of Hayes was found in the glove compartment. An accident reconstruction expert said Hayes had no injuries consistent with the bent steering wheel, and Campbell had no injuries consistent with his knees hitting the glove compartment door. The defense presented evidence that a local TV news cameraman was on the scene almost immediately, and his video of the interior of the car did not show any shoes in the driver's side. And the defense had an accident reconstruction expert who basically said, it's insufficient evidence to conclude one way or another. Either scenario is possible. And the victim's mother testified that she went to retrieve some personal items from the SUV a couple days after the crash and noticed that the driver's seat was pushed far forward and the passenger seat was pushed way back. And Hayes was much shorter. She said, while they were there, she was accompanied by the sheriff's accident expert who pried off the glove box door while she was there, and she didn't see any dent in it or any blood on it. But he was convicted and sentenced to 28 years, and it was affirmed, although it was remanded for resentencing, and he was resentenced to 20 years in January of 2014. So now we're 4.5 years later, he filed a federal petition for a writ of habeas corpus, and in December of that year, a defense motion was granted for production of time-stamped crash scene photographs, as well as all the autopsy photographs. And so ultimately they went back to the state court and filed a motion seeking permission to file a motion for new trial. That was a new one on me, but I don't claim to be, I'm not a lawyer. I've spent just enough time in this area to be a little bit dangerous to myself and others probably, but they said that they had a new defense expert who concluded that Hayes was the driver and that these previously undisclosed autopsy photos showed injuries to Hayes consistent with being the driver. And that timestamp photo of the shoes was taken at 12:34 a.m. and TV video showing no shoes was taken at 12:15. Before this timestamp photo, consistent with the shoes being planted. In addition, as a result, when presented with this, the prosecution had agreed to bring in an expert, an outside expert of their choosing, who would analyze the evidence and concluded that yes, Hayes was driving. Even so, the motion was denied. And so in 2019, approximately 2 years later, the Court of Appeals reversed and ordered a hearing on the motion. And in February of 2020, that motion was allowed. And so the convictions were vacated, a new trial was ordered, and Campbell was released more than 11 years after his arrest. And the evidence was submitted, it was done by submission, and he was acquitted by the judge in June. So what do we have here for contributing factors? False and misleading forensic evidence, perjury, false accusation, official misconduct, inadequate legal defense. Now, would a conviction integrity unit have made a difference in this case? It's hard to say. You can't deny that the procedural delays, and even though a second expert who'd been picked by the prosecution concluded he was not the driver, the case still languished in the court for several more years. This is, sorry for the fine print, just some general observations based on my looking at my experience with Ohio cases. And that is, Ohio prosecutors fight very hard to preserve their convictions, and they file lots of appeals. And some defendants, even after being granted a new trial, when new evidence is discovered, face the prospect of many more months, even years in prison because of the threat of retrial, and the result is Alford pleas for immediate release. I've been writing about this issue for a long time, starting at the Chicago Tribune, and the issue of wrongful convictions, and particularly the issue of official misconduct. And we did a series on prosecutorial misconduct that was published in 1999. And as part of that reporting, I had a prosecutor tell me how he made an improper argument because he believed the defendant was guilty. He thought he was going to lose. And he said it was a rape case. It was a shaky ID. It was only serology. It was weak. He got up in front of the jury and he said, just remember, this guy is just an L ride from your front door. Well, he knew that was probably going to get it reversed. In fact, he did. But what he also knew was that it took 2 years to get through the appeals process, and he was going to keep this guy locked up for 2 more years. Is that right? I don't think so. But that's, there are very few consequences for misconduct. And I can tell you the story of Carmen Marino, which some of you may know.
Maurice?
About. Yes.
Maurice, we do have a question. It's from John Martin. Said, why did the prosecution go to trial a second time if their expert said the defendant was not driving? Why not dismiss the case?
That's a good question. And I don't know the answer to that question, except what I surmise is that they wanted it to be done by a judge and not to, it's a question of, I see this happen where the prosecution doesn't want to be in the position of saying, well, we dismiss this, as opposed to saying.
Sorry, Maurice, this is Pierre Bergeron. I was the author of the Campbell opinion at the.
I noticed that last night. I had not paid attention to it.
I'm a little familiar with it, but to answer John's question, I think it's exactly right. My understanding, and I don't have firsthand knowledge, but it filtered up to me. My understanding is that the prosecution basically laid down at that second trial. Like, they didn't put on any evidence. They just kind of conceded in the evidence put forward by the defendant. And I think, you draw your own conclusion from that. Like, did they just want cover for, to have the judge say that rather than them? But yeah, I mean, why do you go through that if you don't have any evidence to contradict it?
That's exactly where I was going. The cover is I think the right word, Judge. And so you'll have these slides. I mean, a few years ago, Tom Sullivan, who was a U.S. attorney many years ago in Chicago, and I collaborated on a piece for the Northwestern Journal of Criminology on prosecutorial misconduct. And one of the actors that we wrote about in some detail was Carmen Marino, who actually had the Prosecutorial Integrity Award named for him until for at least 4 or 5 years. And then because he was being so tarnished in the courts, it was just renamed anonymous without his name attached to it. But, his misconduct is responsible for 4 of the 7 exonerations, 4 of the 85 exonerations that are in the registry. I'd like to switch for a moment very briefly and take you to the registry to show you. So this is live. Stop that. Sometimes this is an amazing case, a no crime case we just added, and it's out of Kansas. It's of no meaning other than a woman who killed her husband, shot and killed her husband, and then before she shot and killed herself, she called her mother and said, "Pete Coons is here, and he's killed Carl, and he's about to kill me." And then she killed herself, and essentially she framed this guy for her suicide and the murder of her husband, and got away with it for more than 10 years before it unraveled. So here's the browse cases drop down where you can find the longest incarcerations page in all the different pages. There's something I didn't talk about, but it's just kind of interesting. The recently posted cases is by posting date of cases that we post sort of in chronological order of posting, about 50. But if you look down the date of exoneration, you'll see here's a case from 2019 that we just found out about. Here's a case down here from 2018. Below that, a case from 2006 that we found about, 2010. So we're constantly finding cases that happened in the past. And so the registry continues to get more robust. When you go to the detailed view page, and here are the values for prosecutor misconduct, police officer misconduct. There is an OM, official misconduct, tags column. And you can sort by those values. If you look today and say, how many exonerations were there in 2019? As I said, I think our annual report said 143. We're up to 151. So we've added 8 cases from 2019 that we didn't know about in March when we published our annual report. These are the issues page. So we have takeouts, what I call takeouts on articles and on guilty pleas, DNA, eyewitness identification, false confessions, a number of issues. And then on the resources page, we have the all our reports. Here's it shows, it's a live where it shows DNA, non-DNA, and all. It shows you how DNA, the blue line, has really not changed a lot over the years, but the red, which is the non-DNA, has grown. And that really, I think, is a reflection of what DNA has done in terms of providing confidence that things go south in cases without DNA. Because as we know, DNA is not involved in a lot of cases. I don't know it's going to be the majority. I don't know what it is. And so I know I've taken a long time. I would like to leave. I'm happy to stay as long as you like. It's only 9 o'clock in the morning where I am. So, I'm just starting to get warmed up, you might say. Just to give you, these are the folks on our advisory board, Brian Banks, Frankie Carrillo, who are both exonerees, Denise Foderero, Brandon Garrett, Larry Marshall from Standard. Larry Marshall was a co-founder of the Northwestern Wrongful Conviction Center, Jim Petro, as you know, and Nancy, and Barry and Helen. Anyway, I've nattered on a long time, and I'd certainly be willing to take any kind of questions you might have. I'm very proud of what we've done at the registry. I think that by using a criteria and sticking to it, we're consistent. And I think consistency is something that really contributes heavily to reliability. Are we perfect? No, nobody's perfect. But I think that, when I was a journalist, I found that data-driven reporting has far more oomph and impact than anecdotal reporting. And I think that I just wanted to give you at least one example of what the cases look like, the summaries. This is the Campbell case that I was talking about. And so I gave you just a few slides, but you can see that this is quite a long, really a lengthy narrative that goes into a lot of detail. So, you get me going, and I will put, more than a quart in a pint container.
Very sweet,
so
Maurice.
there-
This judge, we have a good question that I don't know that you can see the chat questions, but Judge
I can't.
Savaggio has asked us, or has posted, do you have any recommendation as to how we can use this registry in your work to bring awareness and changes to the culture that, quote, colorable claims of innocence need attention and reform?
Well, I think that we say we count things and we tell stories. And by telling stories, you shed light on things. And I think that it's one thing to present some slides that say, 42% of the exonerations are murder cases. And it's another to have faces of people who are out there. And I think enlisting people who are actual exonerees can do a lot, because they have a voice, and they were a voiceless group for a long, long time. I do think that, one of the things that what we say is we only know the cases that we know about. This is a tip of the iceberg, in my opinion. It's a basement. Because one of the things that tells me that is we're constantly finding cases that happened in the past that we didn't know about. You have 88 separate jurisdictions in Ohio. There are 3,000 counties in this country, and most of them you just can't call up the clerk's office and say, "Had any exonerations today?" This is the only really database of its kind. And I have no idea how many cases there really are. I think that the more that people become aware that we exist and that we collect this data, people can become conscious and say, I talk to public defenders all the time, and I'll say, some that, they don't know about us. And I'll say, well, I'm calling you about this particular case, and do you have any others? And they say, well, not exonerations. And the term is such that it resonates in a certain way with certain people. Some people think exoneration means DNA. Well, 3/4 of the cases in here are not DNA cases. Sometimes I'll just say, do you have cases where someone was convicted and later they got it reversed and they were acquitted or dismissed? And they'll say, well, yeah, well, tell me about those. And maybe some of those will actually qualify. And so you have to kind of put it in those terms. But I really think that there's a case that's interesting, and I forget, that a TV reporter has been writing about. Could it be in Toledo? Where the prosecution's only witness has recanted 6 ways from Sunday. I believe the Innocence, Mark Godsey might know about this project, has been involved, and the prosecution basically said, there's no venue. We're not going to even take a look at this case. It's sort of like the days when people would come in and say, I would file a motion for DNA testing, and the prosecution would say, use all these procedural arguments to go against it. So like, wouldn't you want to just know? If you could know, wouldn't you want to know the truth? When you're based on, prosecutions that are based on, serology and hair analysis and things that are incredibly imprecise.
Do you involve
don't have
research cases that are pending, or is everything that you do in terms of once exoneration has been determined?
And real quick before you
have-
answer, Grace, would you mind if you're done using the presentation to stop sharing your screen? Then if other people have questions, they'll be able to. You'll be able to.
Oh
see
yeah. Sorry, I'm sorry.
Nope.
Sorry. So one of the things that we do is we have an internal database, you might say. It's just a collection of cases that we hear about, that reversals by courts of appeal and follow. And my experience as a journalist is, you get convicted on page 1, you get reversed on page 10, and you get dismissed on page 90. And so, or not at all. And the only way to really know is to try to keep track of these. And so we have a list of about 600 plus cases that are in various stages of motions have been filed for new trial by as a result of DNA test results, reversals, federal writs have been granted to follow up, and probably about 2/3 of those wind up being rejects. But there are many that occur that we would not have known about had we not followed up, because the ultimate disposition never made it into any reportable. So I have a Google alerts that capture different things. I know as a journalist that if I put new trial in quotes in a Google alert, that someone who gets a new trial, that's the way the press almost always reports it. And so I also get a lot of stuff about vaccines now, but and medical trials, but it's easy to sort through those. So it's a way too of gathering. So let's say that I can gather that, I can look at that reversal opinion in a particular case and see that as part of the reasons for reversal, there was exculpatory evidence that was not disclosed, or that a defense witness was not allowed, the judge did not allow that. I mean, that isn't a contributing factor, but we have cases where cases are reversed because judges ruled that the defense couldn't present a witness. The appellate court says, no, that should have been allowed. And it comes back and the case is dismissed. Well, that qualifies because there was defense evidence that was not presented. And it wasn't because of one of our contributing factors, but it was because a judge made a decision that was overruled. But it qualifies. So it's every day I have a dozen or so cases that I can follow up on. And I thank God for states like Ohio where they have online dockets, so I don't have to pester people and I can go to the docket and look up and see what's going on with the cases.
Very good. Thank you, Maurice. Other questions, anyone? Joanna?
Yes, thank you for your presentation. I was wondering if you could provide us some guidance on how we should use this data, because I think we were interested in looking at it to detect maybe where the problem areas were in Ohio. And you touched on this, but it strikes me that there's kind of two ways to look at some of these data points. So for example, 2% of false confessions as a contributing factor in Ohio's known exonerations. We could look at that as Ohio doesn't have a false confession problem, or Ohio has a false confession problem, but also has a second problem in that we lack the mechanism or the process to detect and remedy those cases. And so if you have any ideas on how we should look at that data and maybe comparison with the national data and how we can use that to guide our work, I'd appreciate it. Thank you.
That's a good question. And I was thinking about that as I was sort of making these slides, and false confession is a good one because And I thought, what would I do if I were a journalist and I saw this, and how would I approach it? And I think I would go to the people who bring the cases, who get, you start an innocence project and you hang out your shingle and your mailbox is full the next day. And the same thing happens with conviction integrity units, unless you're really, cagey about, and we find some that they say they got one and they got a little thing on their website, but there's no mechanism to reach out for them to get in any contact. So you're sort of bulletproofing yourself in a way. I would go to the people and say, like, I would ask Mark Godsey. That was my first thought, was if it wasn't, too late at night, I would have called him and I said, do you guys get false confession cases, and that you don't get any traction with? What's the problem? Why am I not seeing these? Because I don't believe that, Ohio's not going to be like Chicago, where you had a group of detectives who tortured people and, wound up torturing confessions out of people, and have a long history of doing that. And so that spikes the numbers there. But that was the one I would look and say, where these cases must be coming to people. And whoever does a lot of wrongful conviction work, those are the people I'd be asking and say, why do you think this is? Because it doesn't make any sense to me to ask prosecutors about it, because the answer would be, well, because all those false confession cases are rightful cases, rightful convictions. I do think that the and I mentioned this to Judge Muda when we had conversations, my sort of personal observation is that Ohio is a state that, generally speaking, is really resistant to this idea that people are wrongfully convicted.
Mm-hmm.
I think if you looked, I would want to look through these cases and say, how many of these exonerations were the result of acquittals at a retrial? And there is an internal coding that we have. We don't use it very often, but is at the time of exoneration, what was the position of the prosecution? So, as an example, if someone was acquitted at a retrial, now I'm setting aside the Campbell case, because that seemed to be a laydown, but it would be opposed, and because they're opposed right up to the end. And I think that some sort of analysis of what kind of cases are how are they being responded to by the prosecution would be valuable. And I mean, I started to look through, I have a list of rejected cases. And by that, I mean rejected for the registry. And that's sortable by state. And I started it a long time ago because I found out that I would be reading about some case, and there would be a reference to some case that got reversed. And I'd think, oh, that could be a potential. I should go look at it. And I'd spend a couple hours digging down and then realize, no, I rejected that case, 2 years ago, because it didn't meet our criteria. So I have this list, and it's now, it's more than 3,000. And I was starting to look through the Ohio rejects, and what I saw is reversed on Brady, Alford, reversed and pled for immediate release, reversed and pled to lesser charge. It's not, and I realized that it wasn't something that I could really cite in any statistical sort of way, but anecdotally, that's my feeling, is that, and I get, this happens across the country, is that people get new trials, and then, faced with the prospect, after, 15, 20 years, it's a huge carrot. And a lot of lawyers have told me I'm not going to tell them not to, they got to make that decision.
Right.
But my feeling is that there's a huge amount of resistance pretty much across the board in the state of Ohio.
Mark Gotze, you have a question or comment?
Yeah, I would agree with that, and I can send around if it's helpful to people. I wrote a book about this called Blind Injustice, and chapter 2 talks about the resistance in cases where the evidence of innocence is very strong, but the resistance causes it to drag through the court system for years and years. Or even, resistance, like recently we got a case back where the DNA testing confirmed that the guy was guilty. But it had to spend years and years and years in the courts because they fought DNA testing. And it's like, well, why couldn't we have done the DNA testing when we asked for it 15 years ago? And that would have ended this. But Joanne asked about the data, and two things jump out at me that I think are connected. One is that there's a low number of false confession cases in Ohio. And two, there's a low number of exonerations where the person pled guilty. And I think, and those are the two data points that jump out from Ohio. And I think those are connected. When somebody gives a confession, whether it's real because they're guilty or false, I think there's a correlation between that and guilty pleas. Because their attorneys tell them you're never going to be able to overcome this confession. And so they're much more likely to plead guilty than go to trial. And then the second thing is that Ohio is one of the few states, maybe it's the only state, I don't know, where the DNA statute does not allow somebody who pled guilty to get DNA testing to prove their innocence. And that is something that, we've amended the DNA statute many times and we fought to make amendments to it, but the Ohio Prosecutors Association has dug their heels in very deeply, and everything's off the table. We're not going to agree to anybody who pled guilty can get DNA testing. And so, as opposed to other states where people who pled guilty can get DNA testing, that's why 20% of the exonerations nationally are from people who pled guilty, and it was 4% in Ohio. They can't get DNA testing here. And so I think a lot of these people who confessed ended up pleading guilty. They write to an innocence project. They write to the Ohio Public Defenders. And the first step is to apply for DNA testing, and so boom, the door's closed right there. As opposed to other states where even if they pled guilty, they can get DNA testing. That to me is, when I look at those two data points, is what jumps out at me.
I would agree with that on the guilty pleas part, particularly.
Yeah.
And when you look at how many people that pled guilty are in the registry, it really tells you got to consider these seriously.
Another question, Maurice, that we have here is, if you think Ohio is resistant to this process, by and large, and you certainly have opined that today, based on your experience and research, can you think of a state that you've come across that is not like that? Or do you think most states are similar to Ohio? In other words, is there a state that, if we're looking for modeling to how the state is organized, where it's more proactive in terms of vetting colorable claims of innocence, as I like calling it, it would be worth our.
I really, I'm going to throw California into the mix for a couple of reasons. One is that the new district attorney in San Francisco, Chesa Boudin, has reinvented, you might say, the Conviction Integrity Unit. And it includes the head of the Public Defender's Office, the director of the Northern California Innocence Project, and a couple others sort of from that background, on the Conviction Integrity or Review Unit as a part of the process. The new DA in LA, who just got sworn in and said, death's off the table. I'm going to have somebody review every current death penalty case with in mind toward being resentencing. And that's something I haven't even talked about. But there are 3, 4, 5 innocence organizations, at least in California. I think that the more that they do work and work with conviction integrity units, it's a changing of the culture.
Yeah.
And it really is. And, you know, I think that George Gascon is going to make a significant, having quite a good impact on the conviction integrity unit in Los Angeles, which is, you know, a huge county and has not done very much in terms of exoneration. And you know that those mailboxes are full.
Yeah.
There. You know, you have, there's an innocence project down at Cal Western, and there's one in Santa Clara, there's one at Loyola, there's an independent one, these are innocence outfits, an independent one's called Innocence Matters in LA. The more that that they work with these conviction integrity units, people see that it can work, and you don't, the ceiling is not going to come in on you. The sky is not going to fall. And I do think this is an evolution that it's become a little bit of a torrent, if I can say that, with that we've grown that many. 72 isn't many, but of course, you know, you were talking about this as I came in, and the issue of finances and counties that can't afford to do this kind of thing. I've often wondered if that's where the AG's office should come in as a function, as a conviction review unit for those counties that do not have the resources, and to let the counties with the resources, you know, the larger counties who have the vast majority of the cases, obviously. I mean, we haven't even talked about misdemeanors, and rightly so, because, you know, but that makes up probably, I don't know, 80% of all prosecutions got to be misdemeanors, probably maybe even higher. We don't, and that's when we don't know. We have misdemeanor cases in the registry, not many, because they don't rise to the surface. But that's a whole area that to me is the depth of the problem of wrongful convictions, and guilty pleas. You know, there's a trial tax.
Right.
And so my feeling is that you can't look to a particular state so much as you got to look to units themselves and the impact that they can provide to the sort of the writ large landscape.
Thank you very much, Maurice. Anyone else? It's 12:20. No, I don't see anyone else. Maurice, I want to thank you then very much. Excellent presentation. A lot for us to digest. I appreciate you letting us, you know, you tendered your slide presentation to us. So this has been recorded. We will also post that slide presentation on our website at our task force tab of the Ohio Supreme Court website, I should say. So that will be made public now for others to review. I really appreciate this opportunity that you've presented for us as we continue to strive and work forward to improving our lot here in Ohio, and how these cases can be better managed and handled, and justice properly served. Thank you.
Well, I really appreciate. I'm sorry, Judge. I really appreciate the opportunity, Judge, and your patience and everyone. And we're always here, is what we say. We're a small staff, but we have people in East Coast time zone, and I'm in the West Coast. So we have pretty close to, you know, 16-hour maybe a day coverage of people but we're willing to provide data, ask questions. We have internal data, as I mentioned, that we sometimes part with depending upon the use and what the data is or are. So if I can help in any way, I'm really more than willing. I appreciate it.
Thank you very much, Maurice.
Thanks,
With that,
Judge.
that concludes our meeting. I want to tell everyone, let's see, well, we've already scheduled our next meeting January 15th at 10 a.m. by way of Zoom. And is there any other issue that anyone would like to raise for the good of the order before we sign off? Seeing none, thank you all for your time. I hope all of you have a great, joyous holiday. Stay safe,